political parties understand there's a big issue here. We've gone over, but I want to leave some time for some questions, at least before we go. Mark Tapscott, Washington Examiner up front here. I think we have a microphone so folks can hear. So we're going to take one of the microphones from here, and if Dan and Joe could share.
I want to go back to the meeting, the briefing that Clinton got, presumably, at the outset. If I'm Patrick Kennedy in that meeting, the Undersecretary for Administration, and I say to her, you use the government email, and she says, no, I'm going to use my own. What are my legal responsibilities and obligations at that point to attempt to ensure, or at least to memorialize, what happened in that meeting?
This is a civil matter, so I'll take it. And
For the moment.
For the moment, right. And I can only speak in comparison to what I know happened at the Justice Department every time there was a new Attorney General. Routinely, this sort of administrative meeting would be held in one form or fashion sooner rather than later. And I would dare say the top administrative career official of an agency has the responsibility, A, to make it clear what the law and policy requires, to be more refined and say, well, just because you're not flatly prohibited from ever using a personal account doesn't mean you can always use a personal account. There's a lot of daylight in between the two. And assuming the worst for this purposes of this question, that he learned in that meeting, if he in fact was there, and we're speculating, okay, that she did not intend to do that, then I believe he would have had an obligation at a minimum to contact the people at the National Archives and Records Administration who hold the statutory responsibility for overseeing and properly implementing the Federal Records Act, up to and including the Archivist of the United States, with the idea that the archivist, having learned of this development, would then call the secretary and say, Ms. Secretary Clinton, you just can't do that. It's not consistent with and indeed flouts the Federal Records Act. If, on the other hand, he didn't learn that, or no one learned that, it was just stated to be what should be done, and then she went away and did what she did on her own, then the question would be, well, when was that learned, and wouldn't that same obligation arise?
Which is the next part of my question. At some point, it became obvious to a bunch of people there that she was using a non-government email. Is there an obligation at that point?
Well, I'm going to cut them, those people, those anonymous people as recipients, I'm going to cut a bit of a break, so to speak, because they don't know, as mere program people, they're not administrative people, they don't know what took place in the meeting. So maybe they can assume, they're not supposed to be experts in the Federal Records Act, maybe they can assume that it's okay. And I don't think they have a direct obligation to do otherwise and to take any action. It really is on the administrative people who have the delegated authority from the archivist to make sure that the Federal Records Act is followed at that agency. So if the records management people learned thereafter, yes, they indeed would have that. But if the Assistant Secretary of State for Far Eastern Affairs learned that, that would be a different matter entirely.
Let me add to that, if I might. Your question is actually at the heart of the matter. Mr. Kennedy is a very important person in this entire scenario of records production and of policy issues related to record production. Mr. Kennedy is one tough cookie. He ruins people's career for a living. That's what he does. He is an apparatchik in every sense of the word. When and if he was the person who briefed Mrs. Clinton on what her duties were, I can assure you that it would have been a groveling presentation. The bottom line here is that whatever the duties were of a whole bunch of people at the State Department, they didn't perform them. I agree with Dan. You can't put the onus on this on the people inside the State Department getting emails from Hillary. They don't know. That, as far as they're concerned, that's one email. They don't know where she is or what she's doing. At a certain point, the information management people at the department know that she's not using an official email account. They know that for a fact because she doesn't have one. It doesn't take a lot for somebody to start asking questions like, excuse me, Madam Secretary, but just how are you communicating with people in the department? And where are those records? This is so staggering in the brazenness of evasion of legal duty by everybody at the State Department, and especially the Secretary, that it is simply staggering. It's unbelievable. And with a straight face, she stands up at the UN and talks about yoga lessons and laughs about it before a media group recently and makes a joke about her emails. And of course, the media in the audience laughs uproariously at this wonderful event. What she has done has undermined people's confidence in the ability to get valuable public records. Her records were valuable. Whatever you may think of her, she was the Secretary of State. That's a pretty big job. And she took it upon herself to change history. She does not have the right or the authority to change history, and she did.
And Mr. Kennedy is still at the agency, still is the responsible official for record searches and managing records and that separation agreement. The idea that there is a distinction between Mrs. Clinton personally, she is the agency for legal purposes here, and there's no daylight as far as we're concerned between this current State Department and Mrs. Clinton. This is State Department responsibility, and the folks there is liable, potentially, as Joe points out, as others.
Can I just make one minor little point? Because there are a lot of facts here that are undisputed. They come from Secretary Clinton herself or from people speaking on her behalf. But I don't know for a fact that Patrick Kennedy was in such a meeting. For all I know for sure, he might have been having surgery that month, and it could have been a deputy or two deputies or something like that. We really do not know for sure. But the responsibility is in his office for somebody to take the lead on such an important matter.
Well, there have been several court filings since this scandal broke. And I think we have all the lawyers here from Judicial Watch who have been involved. And I think I'm correct in saying the State Department is yet to disclose to us when they became aware of these accounts of Mrs. Clinton.
Now, also, I agree completely with Dan said about not knowing who it was. But here's a better question. How about if she didn't get a briefing at all? And I'm going to tell you something. She didn't. She didn't get a briefing. Because they treated her exactly the way Thomas Pickering of the Accountability Review Board treated her. You don't touch her. You don't get her angry at you and Cheryl Mills angry at you by asking tough questions. You treat her like a queen. She gets a pass. She doesn't have to do anything. I would be amazed if she got the traditional briefing that other secretaries of state have gotten when they came into office.
Right.
They probably would have given it to Mrs. Mills.
I'm going to agree with you with your speculation in one respect. I happen to know firsthand that there was an Attorney General of the Justice Department who was treated not unlike that. So that makes it a little more plausible that it might have worked there, and that was Alberto Gonzalez. And when I deposed him for 6.5 hours down in Lubbock, Texas, on his understanding of the Federal Records Act and the Privacy Act, that became painfully clear.
We have time for one more question. Yes, sir. In the center here.
I seem to remember the department has a category similar to for official use only. I think it's is it LU, limited official use, something like that. It's above unclassified but below classified. And I'm wondering that so many of the daily emails with the department, if they're not classified, they would probably be this LOU category. It's like official use only. And I'm wondering, does that make some difference on the security or lack thereof of the server up in New York?
Well, having some familiarity with what's called sensitive but unclassified information, because I wrote the damn White House memo in March of '09 that started everything off on that. I do know that the State Department uses at least two such designations in what's known as the pseudo-secrecy realm. One is called no form, and the other is NODIS, NOFORM, NODIS, and it might be used for official use only or something like that as well. What that has to do with is labels that are attached to records, most easily in the paper realm, that call for special safeguarding and special handling. And your point, I think, is a good one. I touched on it in the Political Magazine article that I wrote a couple of weeks ago, that even if nothing on her server was classified, which is what she has said, and for all any of us in this room know, is entirely possible. It was not reviewed for classification, which is another matter, but even if that's so, it's very, very hard to believe there wasn't at least some SBU, sensitive but unclassified information of that level, that was there, for which a special handling requirement would have been warranted under how the State Department ordinarily operates.
Well, if we take Mrs. Clinton at her own word, that this server was private, it didn't have the security requirements that State Department servers would. So just imagine the types of information that would be left on the equivalent of an internet park bench by Mrs. Clinton as a result. You have classified information potentially, you have personnel information potentially. Personnel issues are presumably part of her handling, a part of her day-to-day duties. So someone's personnel files are on the internet park bench. Someone's Privacy Act protected files are on the internet park bench. Sensitive information from abroad are on that internet park bench. Maybe sources that need to be protected are on that internet park bench. Maybe the private information of corporations doing business with the State Department are on that internet park bench. Maybe security concerns about Benghazi and or security issues related to other diplomatic facilities are on that internet park bench. You can imagine those who would be interested on that. So you have all this information that as the agency head, she's supposed to protect. And in protecting that information, she's protecting other people in the agency and citizens outside the agency and other government officials outside the agency, both here and abroad. So there are a lot of people who've been harmed by this misconduct potentially, if this was not secured as it was supposed to be. And so this is why you get the reaction that you're getting from Joe Geneva. And, you know, as Paul pointed out, we've been gamed as well. But we have access to the courts. We've got great lawyers. But there are a lot of people who know they've been gamed out there who don't have access to the courts and probably will never get justice by this. And I'll just close on this note. You know, as I said, I think this whole case was broken open because of our insistence on getting information from Mrs. Clinton and her office about her involvement in the Benghazi scandal. And we talk about the Benghazi scandal as if it's just a political issue, but it's about whether or not 4 Americans
got killed,
died unnecessarily as a result of decisions made by Mrs. Clinton and the Obama administration, both in terms of refusing to provide them security that was requested, security that was pulled out eventually, and then once the attack began, not going to their aid. So there are people who have died that need to be vindicated. And that's why we were investigating this. And the lack of and the failure to go protect those people, the failure to provide them security, and then lying about what happened for political purposes has really decimated the morale of the military and other civilian personnel deployed overseas. Because the compact has been that if things hit the fan, the government will be there to save us. And we were investigating why that compact was torn asunder by this administration. And this is what we uncovered. And in the light, and even after all that became public, and the controversy, the select committee asking questions, this person, Hillary Clinton, deleted all of her email by the admission of her own lawyer. Really incredible. So this is not your typical political scandal. There were no dead bodies in Watergate.
Tom, could I just touch on one point with respect to the word delete? And that's a relatively recent development as of Friday of last week, when I believe the phrase used by the Gowdy committee or subcommittee is that he heard from David Kendall that it was wiped clean. I'm told by my technical experts, which are largely my computer security daughter who works for Google out in California, that traditionally